All right. Anyway, so let me get started on the Courthouse 101 class. Like I said, we have a rotating series of classes, and we're gonna, I think we have 7 classes split between myself and Andrew, and I'm going to send each of y'all a copy of this PowerPoint, and it talks about on one of the slides some of the other classes that we have. We're gonna, we've had this group of classes for a while, and we've added to them, and we keep our courses updated. But we want to also add some fresh courses. So we're kind of thinking about some different topics, maybe to add a class or two. I'm thinking of possibly doing a class geared towards evictions and so forth, which is something that our patrons deal with on a regular basis, unfortunately. So, like I said, my name is Jonathan Briggs. I'm the assistant law librarian here, and we have 3 other people who work at the law library. Andrew, our branch manager and law librarian, and then we have 2 part-time assistants, and both of them are really good at their job as well. We can't give legal advice. We try to provide as much information and resources as possible, and it's not that we're closed mouth. There's just a line we can't cross in what we do. We try to answer questions as best as possible. Kind of about what we know about being law librarians and what we know about the Fort Bend County Justice Center and so forth. But we just can't cross that line into legal advice. So, this course is going to provide kind of a general overview of sort of getting involved in the initial stages of civil litigation. How do you become involved in it, and what are some of the issues at the outset of becoming involved in a case? And then to talk about the Fort Bend County Courthouse, or as we call it, the Justice Center, and the offices here and the resources we have at the law library to assist you. Like I said, I have a companion course to this, which will probably be done in the next few weeks. We usually try to do them close to each other. Courthouse 102, we kind of pick up where this course lets off and say, now you're involved in a case, sort of what then? What are some of the issues that you'll be facing, the structure of cases, and what resources we have to help you, work your case towards its ultimate conclusion, whether that be a trial or some type of hearing or a settlement, resolution of the case, or dismissal of the case, what have you. The Fort Bend County Law Library has been around for a little over 31 years now, and we're part of the library system. Fort Bend County obviously has a library system, regular branches throughout the county. We're part of that. We're a little bit different than the other branches. We're not a lending library. We're a research library or reference library only. But we do have, a lot of resources, and we have various ways of sending out those resources or having people get access to them. So, obviously, Fort Bend's grown a lot over the last 40 years or so. When I became a Fort Bend County resident, I think there was maybe 100,000 people living here, and now it's over 800,000 folks. Like I said, we're not funded by taxes. Our funds come through a portion of the fees that are paid when people file civil cases. So when a person files for divorce or files a personal injury lawsuit, the filing fee is somewhere around $300, and we get a percentage of that. We then take that money and spend it well. We spend almost $300,000 a year just on maintaining our materials. We have books, we have computer access subscriptions on several of our computers to the up to date and very definitive legal websites, Lexis and Westlaw. So we spend the money well. Just speaking I'm an attorney as well. As looking at it from the eyes of a customer of this library, I'd say it's an excellent law library. I'm not just being partial myself. I think I'm being pretty objective in saying that Fort Bend County provides a really good law library to its residents, but it's open to anybody. If you live in Harris County or wherever, you're welcome here. We're administered, we're kind of run by the law library, by the library system, but we have some oversight obviously by Commissioner's Court and by our committee. There's a law library committee made up of attorneys and judges who kind of oversee our operations as well. We're here Monday through Friday, 8 to 5. And like I said, I'm kind of going to skip through some of these deals. I just don't want to belabor some of the slides, but I do want to. I am going to provide this to you, so you'll get the full information in the PowerPoint. Like I said, this talks about our other classes, our website. We have a Facebook page, so you can kind of keep up with things that are going on with us, our schedule of classes and so forth, and just events and information about us. So let's kind of jump into sort of the meat of the course here. If you're pro se, that means you represent yourself. That's a Latin word. There's a lot of Latin that's used in the legal system. Cases are so you. In most instances, you're allowed to represent yourself in court. Some people might say, it's not the best idea, but sometimes people, they want to represent themselves, or they feel the matter is, say, simple enough to handle themselves, or they might just have no choice. Attorneys don't come for free, and people want to try to handle things themselves for various reasons. Like I said, cases are kind of broadly divided into criminal and civil. Criminal cases is pretty obvious what that is. Civil cases, there's a lot of different subcategories of civil cases. Civil litigation, personal injury litigation. If you have a car wreck, that's part of civil litigation. If you had a contract case, either yourself or say two big companies are arguing about business issues and one sues the other, that's a civil case. Probate and estate, that's kind of a subset really of civil cases. Family law is a part of the civil court system. So there's a lot of different areas, and there's some other things as well that fall under the broad umbrella of civil litigation. Like I said, criminal cases, we kind of talk about this a little bit here, though it's not a lot of what we deal with as law librarians, at least as far as helping pro se folks. We do some, and we also assist the attorneys who come in here with accessing materials for criminal defense cases, forms, and what have you. So there's the broad category of criminal law. Then there's misdemeanors and felonies is how it's generally divided. Misdemeanors are the more minor crimes or more minor crimes, such as certain level of theft, DWIs, and so forth. Felonies, it's murder and robbery and those kind of more serious crimes. Like I said, civil litigation, this slide kind of talks about all the things that come under that broad category. There's not all the courts of Fort Bend County are in this building, but most of them are. So the law library is in the Justice Center, and we're here just outside of downtown Richmond. We're across the street from the sheriff's office and jail. The big building with the clock on it. This building's been here about 10 years or so, and it's been expanded once since then. So the district courts are in here. There's 8 of those, and those are kind of the highest level of trial court in Texas. And so it handles civil matters from $500 amount in controversy to infinity. So, you can have certain cases that, even though they don't have a lot of money at stake, can fall under the district courts, then up to, infinity. You have some big case between 2 giant companies and, maybe $1 billion is at issue. Well, that can be handled by the district courts. And then it's also broken down by jurisdiction, not just by the money that might be involved. Some cases don't involve money directly, but there's certain types of cases, certain subject matter issues that are handled by the district courts, and we can provide information on that. And the district courts are then broken down here at Fort Bend in a couple of ways. There's 3 courts that are family law courts, and then the other 5 listed here on this slide are the general civil and criminal courts. So they handle those, personal injury suits. They handle the felony cases and so forth. And then the other 3 courts, the family law courts, that's all they handle is the family law cases. And it's a lot of what goes on here at the courthouse. The 2 biggest things that go on here at the courthouse are criminal cases and family law cases. And then everything else, all the other civil cases and probate matters and things of that nature sort of come in third place as far as the overall volume of cases. And so these family law courts are very busy. There's 3 courts with their elected judges, but then each court has an associate judge that assists with the docket, and those judges are appointed. And just the usual type of stuff that you would think goes on there, divorces and child custody matters. But a lot of other things go on in there as well. Family law actually handles name changes. It's a fairly common thing here for people to file for name changes for either adults or for children, all various reasons for doing so. It's not a massive amount of cases, but it's a regular thing that we assist people with and giving them forms and information. It kind of surprised me when I started working here that it was done so regularly. Like I said, the judges, there's associate judges that assist the district courts, both the family courts and the other ones as well. Um, they kind of handle, I'll say the overflow, but they just handle the volume of cases that are on the docket, and the judges have the authority to really handle almost anything. They can even preside over trials themselves with the consent of the parties. I do know that there's a provision in the family code where if an associate judge gives a ruling on an issue and you want to have that, if maybe you're the person that doesn't like the ruling, maybe if you want that reviewed, you can do so. You have to act quickly to have the presiding judge do that, and it's come up a few times, and so there is particular paperwork for that, and it kind of shows a little bit the difference between the elected presiding judge and the associate judge. The associate judge has some. It's a little bit different since they're not elected, and their powers and sort of their ability to be reviewed by the presiding judge just shows that they're in a little bit of a different category than the presiding judge. But they're really competent, and they do a lot of great work as well. Then there's the county courts at law. That's sort of the next, I would say lower tier, but just another type of court here. There's 6 of those. It's kind of, I would sort of say, the mid-level trial court for Texas. There's some differences, obviously. There's a reason they exist in addition to the district courts. So they handle civil cases as well from 500, but they're capped at 200,000. I think that's still correct. It might have gone up a little bit, maybe to 250, but anyway, somewhere around there. They handle certain civil matters, of a certain range. So you can't seek, more than $200,000 in a personal injury suit that you file in the county courts of law. They handle misdemeanor criminal cases. Here in Fort Bend County, the county courts of law are also the probate courts. So if you have a will that needs to be probated, guardianship matters that come under the probate deal. Say if you have an adult who needs to, have someone basically overlooking them, sort of the ward guardian relationship. Often happens when an adult becomes, say, mentally infirm, and a guardianship needs to be set up to manage their affairs. That can be done. That's done through the probate courts, and so it's a little bit different. There's 6 of those here, and they're all in this building as well. So all the district courts and all the county courts at law are in this building. Then we have the JP courts. Those are the Justice of the Peace courts, also called small claims courts. And there are 5 of those JP judges around the county. They're divided up via precinct or by precinct, so kind of geographically. So here in Richmond, the Richmond-Rosenberg, Needville area, that's precinct 1. This is kind of the largest precinct geographically, I know. It has actually 2 JP judges, one in Needville and then one here actually in Richmond right across the street in a smaller building across the way. So there is one of the JP judges right across the street. The rest of them are in Missouri City, Katy, and Sugar Land. And their jurisdiction, they also handle civil matters. They handle traffic and county code violations. Like I said, they handle the small claims suits. Disputes between people, disputes between maybe a person and a contractor who, you hire somebody to remodel your bathroom for $10,000 and, something goes off and you need to sue them for not maybe completing the job or something like that. And it's, 10 grand and that's what you want to sue them for. That might be something you want to, that you can do in small claims court. It recently went up from 10,000 to 20,000 at the end of last year. Just obviously keeps on going up. It's sort of what do they call that? Inflation, I guess. And also one thing that the JP courts handle is what are called forcible entry and detainer. That's a fancy terminology for eviction cases. They have original jurisdiction over eviction cases. How eviction cases might go if they need to be appealed is a little different, and that's probably what I would cover in my eviction course, part of that. So that's another part of the JP court, probably a large part of their docket are evictions, unfortunately. So I think I talked about it a little bit. Let me go ahead and just talk about it without looking at a slide. So each of the courts systems are assisted by their own clerks. So the district courts are assisted by the district clerk. County courts of law are the county clerks, and then each JP court has its own clerks to handle the paperwork, essentially, and sort of the assist in the running of the whole system. So, the district clerk and county clerk's offices are here in this building. The JP clerks are obviously with each JP court. The county clerk also, in addition to handling the litigation side of things, the filings in the county courts at law on both civil and criminal, obviously they have an additional role in that they handle like real property records, the vital statistic records, death certificates and things of that nature. So they have a little bit of a very more varied role than the district clerk. The district clerk is, really just to assist the district courts in the maintaining of all their files, where you get material, where you file materials. All the clerks obviously can handle service issues and getting suit papers served on parties. So they're here in this building as well. They're in the new wing actually. Also in this building is the district attorney's office, a portion of the county attorney, though some of the county attorney is in the old courthouse building. I think the public defender has also moved into this building, I think just recently. And let me go look at the chat here. I think Ms. Mafud has asked, do you think the courts will continue conducting Zoom hearings after COVID, allowing agreed settlements via paperwork submission? That's a really good question, and I do talk about kind of the COVID protocols here, as you can see from this deal. It was kind of something that had to come about through necessity, adding the Zoom deal and making people do things via Zoom, not just adding as an option. Obviously, during the last, unfortunately, it's been almost a year, during this last year, they added Zoom hearings. They've added people, kind of completing divorces and so forth on paperwork if possible. I think it will. I mean, this is just me talking. This is my opinion. I think it will continue. It gives courts and parties options. I think it might lessen some once we get back to in-person hearings. Zoom might not be the default, I guess you could say, but it might be a real option for people. It's convenient and so forth. I think sometimes, nothing beats having both parties before the court in person. But I think the courts aren't just going to. My thought would be, why would you completely abandon it? It can be very helpful. And the same thing maybe in. I don't know about the paperwork one. Possibly. In certain divorce cases, not all, obviously. The parties are at least in some type of agreement where they can agree to, they have an agreed decree, the final document order from the court, and then they have the affidavit that stands in for the hearing that used to have to be conducted for a divorce. So it's a possibility that might stand too. Like I said, why completely retract everything that has been added? Instead, kind of let's go forward and use it smartly to assist the court and the litigants to get through things conveniently, while still adhering to the requirements of the law. Just from looking at our own standpoint, we didn't used to, here at the law library, we didn't use Zoom or WebEx for hosting or conducting classes. We added it on, once we realized this was going to be kind of a long-term issue. And, so we used to just do things in person. Now we have we started doing things via Zoom, and we switched over. The library decided to go with WebEx as their meeting provider. And so we've, been doing this now for about, since May of last year. So we're really about 9 months. We've been doing it this way. I think probably going forward, when we do get back to having people in the law library, if they want to come in for classes in person, we'll do it probably both ways. We'll give our classes in person, but we'll also have it set up so that people can attend via Zoom. The more the merrier, and it probably increases people's ability to attend, because we recognize that, we're only open, the law library is only open during the week, during business hours, and it can be hard for people to break away and come and travel somewhere. And if we can offer it via Zoom, then that's better. So I think that's kind of the plan going forward for us. Um, Obviously, as I say in this deal, keep a track of what the courts, how they do. The courts have their own websites, and it's really important when you do get into a case to go on to your court's website. Access through the Fort Bend County primary website, and there's under the government tab, there are sub pages on that deal. In each court, the district courts have their page, and then each court within that have their own page. Each judge has their own procedures and policies and stuff, and it's really important for anybody to get on there and utilize that to help them navigate the process and comply with the court's procedures on how they manage their docket. Very important. And stuff about Zoom and so forth are included on there. They've also got forms and such. So really, in certain forms, they're really important to do that. For pro ses and attorneys. When I was in practice, I always looked at the court's particular rules. Even before they had websites, they'd have their printed up rules on their protocols, and it's really important to do that, just how they do things. Like I said, the law library, we've been impacted by this, as everybody has, and we've had kind of various ways things have been done over the last few months. We've had periods where we were able to allow everybody back in the law library, limited by a certain number of people, social distancing and that sort of stuff. Given the case counts that have fluctuated and gone back up, we had to go back to where we can't have anybody come in at this point. We've had periods of time where only attorneys were allowed in. So right now we're at the point of we can't let anybody physically inside the law library, but we help people at the door, and we've been able to do a lot of work in that way, providing people some standard forms, fill in the blank forms, or at least meeting with them, talking with them, getting their information, and then following up by sending them things via email and so forth. So our access information is here. You're welcome to come down, come to the door, but also if you need to give us a call or shoot us an email, this email is here, and my personal email or for here and Andrew's is included in this presentation as well. So being involved with the courts, we've all heard of jury trials, and again, with COVID and stuff, the jury trials have kind of fallen off here. I think there's been very few under differing circumstances that maybe necessitated there being a trial by a jury. I think they're also doing things, trying to do things remotely where the jury attends remotely and the and the attorneys and so forth. So it's difficult, to sort of come up with a new system of things by video. I think they have gone on in this county and in other counties for sure. And so people are kind of making do, but in large part, sort of the trial by jury system at the moment is kind of largely on hold. Unfortunately, I think, like I said, there has been, and they're kind of ramping up a little bit, trials by jury, but it's been limited, of course. So most people, probably have done jury duty at some point or other, and that's an essential function. As much as sometimes it is an inconvenience for people, it really is one of our, foundations of a democracy, and is really important to, sometimes you say, well, I don't want to do it, but you want it there if you were the person being judged. So it's an essential deal, and we know it's a sacrifice when people have to come down and do so, but it's a worthwhile sacrifice. But most people, like, if you can avoid coming to the courthouse outside of coming for jury duty, most people you do just fine if you never had to come here. It's not that this is a bad place, not quite the contrary, but if you come here, it means you're involved in some kind of legal issue that you're having to take care of, and it can be at times very serious. And we take that seriously as well. We know when people come here for our assistance, that they're dealing with something important in their life, and we take that to heart and try and do our best to provide materials and such that will help them with their legal issue. So how do you become a party to a case? You might sue somebody. You might get sued. Obviously, you might be a party to a family law case, or you might be an interested party to a probate matter. So you get sued, or you get brought into a family law case as a respondent. In a family law case, you're either the petitioner, the person who files the suit, or you're the respondent. And there's different nomenclature for different type of cases. Typical personal injury civil suit is plaintiff versus defendant. Jane Doe versus John Smith. A criminal case, it is the state of Texas versus John Doe. So that's kind of what this slide talks about. In a family law context, sometimes people think they got to be the first one to get to the courthouse if they're gonna win, their divorce case, and that's not the way it works. The petitioner, the person who files a divorce case or other family law case, is not in a better position as far as the law is concerned. It treats each party equally. So if you're the wife files for divorce and you're the husband and you're the respondent, it doesn't mean that what she wants is going to happen, or vice versa. I think sometimes the petitioner might have a little more, not say control, but maybe drives the bus a little bit more in sort of the process. Maybe when the hearing is going to be set, things of that nature. They're the one that took the initiative to file, so they might have a little more control, I guess, over sort of the timing of certain things. But in a case, be it civil or criminal, family law or personal injury, it's you be both reactive and proactive. Just because you're the defendant doesn't mean you always got to be on defense. You can be proactive in your case as well. So all that being said is the parties are kind of on equal footing. They have sort of somewhat different roles because of the type of party they are, but the law is supposed to see each party equally when they come before the bench. So a couple of, just kind of getting to some of the bread and butter issues and some of the terminology that you're going to face when you're involved in a case. Venue and jurisdiction. Jurisdiction is the power of a court to hear a case. And it also is the power of a court to hear a case involving the parties. So those are sort of the issues of subject matter jurisdiction, such as the family law courts have subject matter jurisdiction over family law matters, such as divorce. To get then personal jurisdiction over the parties, the petitioner, the respondent, in a divorce case, the petitioner acquiesces to jurisdiction of the court by filing their petition. The respondent, in a traditional sense, then has to be served properly to be made a party to the case. And once they have been served and generally file an answer, they now are a party to the case, and the court has jurisdiction power over both parties and the subject matter of the suit. Venue is where the suit is filed. Where is it proper to file the suit? That's looking at the county. So there's different venue rules for different types of cases. And these are covered by Chapter 15 of the Civil Practice and Remedies Code, one of our resources here at the Law Library. We have it in many modes. The book, it's on the computer, and so forth. So say the venue of a divorce case. Typically, it's at least one party, the petitioner or the respondent, has to have lived in the county where you're going to file for the appropriate amount of time. I think it's 90 days. Same with jurisdiction. How does a state of Texas get jurisdiction over a divorce case? It again goes to the time at least one of the parties has spent in the state, such that the state now has a legitimate interest in it, i.e. in the family law cases of its residents. So venue is, what is proper county to be filed in, Fort Bend County. Let's say I live in Fort Bend County, I'm married and I want to get a divorce, and I've lived here for a year, I'm good to go. I can file here, even if my spouse, soon to be ex-spouse, lives in Wharton County, or Harris County, or Dallas County, or wherever. Obviously, there's some. So the way a person becomes a party to a case, as we kind of talked about, being served is a traditional way that a person, being formally served is a traditional way a person or a non-person, like a company, becomes a party to a case. So when I file that personal injury lawsuit, I file it with the clerk. I ask the clerk then to also issue citation, and that is a formal notice that will go with the petition. The petition is the document that usually starts a civil lawsuit. I file a petition. I am, say in the divorce case, I am the petitioner, or I'm the plaintiff in a civil lawsuit, and I file that with the clerk, and I pay the appropriate fee. That clerk also then issues citation. When I go file, I usually take at least one more copy of it. They keep the original, and then the other copy becomes the service copy. And along with that citation, which is formal notice to the defendant or respondent, informs them that they have been sued. It's kind of a cover page, really, that is given along with that petition, and that sort of makes up service of process. Then let's say a deputy goes out to that person's residence and knocks on the door and says, "Are you Bill Smith?" "Yep." "Well, you've just been served," and they give that citation and a copy of that petition. That's sort of the traditional way, and that's still used quite often. There's a variety of other ways that things can be done as well. There's different processes. Say if you're suing a corporation, even though McDonald's, say I slip and fall on McDonald's and it's on Highway 6 and or whatever, I don't just walk up to that McDonald's and go to the manager and say, here's I'm serving you with this papers. There might be, well, it could be, but most likely is it's a company. You want to sue McDonald's Incorporated or whatever. Well, you don't go to the local McDonald's to do so. They're a national corporation here in the United States, and they might be headquartered out of Delaware or New York or something like that. So how do you do that? Well, there's just different ways of doing that. Usually you have to serve the Secretary of State or their agent for service of process here. And so it's, well, not to get too complicated, but there's different ways of serving different types of parties, whether it's a corporation, an individual, a partnership, a government entity, and so forth. So there's different ways of doing it. A lot of the stuff we deal with here is dealing with real people, human beings, and how they are served. Like I said, it's typically via in-person service, say by that deputy or by certified mail, but there's different ways of doing so as well. In a divorce case, often, and sometimes the parties are at least agreed to get a divorce, and that can make things at least a little bit easier in some of the deal and how you maybe serve people. There's an option now, what's called a waiver of service form, that's mentioned down here at the bottom of this. So instead of having the court going through the whole process of having the clerk serve them, have them served formally or by a certified mail or in person, you can take a copy of that petition and take that waiver of service form. And if you can safely do it, you can simply hand that to your soon-to-be ex-spouse. And if they want to, it's voluntary, they can waive formal service of the suit by executing this waiver of service form in front of a notary, returning it to the clerk. They've now waived that formal service that they are legally entitled to. But it takes, you don't have that expense, whatever, $75 or $100 to have someone personally served here in Fort Bend County. Or you don't have to pay that private process server, say if they live in another county, or you don't have to have it sent certified mail, and it takes out I don't say it's drama, but it takes out that unnecessary step of having a deputy come out and knock, knock, knock. You've been served. Just hand it to them. If you're civil to each other and it's safe to do so, and you save yourself a little money and save a little bit of the process. There's other ways things can be done. Sometimes people can't be found. Don't want to be found, you've lost complete touch with them. So it doesn't mean the case can't go forward. It just adds a certain amount of time to the process. There has to be some extra steps. You can have what's called service by posting and service by publication, depending on the circumstances in a family law case. You might have to basically service by posting means essentially the suit papers are posted on the bulletin board here at the courthouse, or service by publication. They're put in an ad in the legal notices at the back of the newspaper that nobody ever reads. And even though technically these probably won't reach the people who they're intended to reach, it will suffice for due process. Once you've shown the court that you tried to find them, you've given a sufficient showing to the court that you went through the steps to try and find them, and you have to issue an affidavit and everything to support this. Under the right circumstances, the court will allow this type of service. There's also, just because somebody never wants to come to the door, there's also substituted service. So say that deputy went out to the door, knock, 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 nobody ever answers. But they're there. Either they never quite catch them, or they just ain't answering the door. And the sheriffs don't have the ability to just knock down the door to serve civil process on somebody. Or a process server, a private process server. under the same thing, similar showing to that, hey, this is a good address form. We know it is. We never can find them. You can get permission for basically the suit papers to just be taped to the front door. So anyway, there's just, there's initial issues on, service is a key issue in litigation. And it's really important. The rules of civil procedure have kind of finally caught up to some of this in that, it didn't used to be allowed to serve things via email or via social media, via messenger or something like that. So now, again, under the sort of the same framework, if traditional service fails, you truly tried the proper processes, and this person just is not getting it. Under a similar showing to the court can rule and issue an order that the person can be served now maybe via email under Rule 106. So that was a recent amendment to the rules of civil procedure, kind of keeping up with sort of the times a bit and adding that in. So it's really important, I guess, and I emphasize this a few points in this PowerPoint, is don't ignore stuff when it comes to you. As much as as it might be unpleasant to deal with, if you get served with suit papers, know that the clock is running for you to react in some way, shape, or form. Typically to file an answer, but if you're going to also challenge something, file something at the beginning of the case to maybe challenge the court's jurisdiction or the venue. Those type of things have to be done. So, you just have to react to things. Otherwise, if you don't react, a default judgment can be entered against you. Your ability to challenge the jurisdiction of the court can pass. And if you get a default judgment and something as important as an issue regarding the custody of your children, those things can happen. If you don't respond, if you ignore things, the case will maybe go on without you, and typically that means a less than favorable outcome for the person who is not participating. Like I said, default judgment is a possibility, so you got to react to when suit papers are served on you. That's typically done by filing an answer. Like I said, there are some issues that come up that have to be dealt with at the outset. The answer's filed according to the timeframes listed in the citation. But if you want to challenge the jurisdiction of the court, let's say, I was never served, or this court doesn't have jurisdiction over me via subject matter, or I'm not amenable to jurisdiction. I've never, say a Texas court's trying to assert jurisdiction over you, and you live in Montana, and you say, I've never been to Texas. How can I, maybe have jurisdiction be asserted over me? Well, there might be issues that allow you to challenge that successfully, depending. Maybe you never been to Texas, but I'm a Montana company that sent a product to Texas, so maybe that actually is sufficient enough. But long way about saying is, if you want to challenge the jurisdiction of the court, the power of that court to hear that case over you, you do so by a special appearance, and that has to be filed first before any answer is filed, and that answer will be filed subject to that special appearance. If you want to challenge the venue, like, hey, I got sued in Fort Bend County, that's wrong. I should be transferred to Harris County or Wharton County or Waller County. Well, you have to file that motion to transfer venue first, before you file an answer. It's called the due order of pleading, and we have materials that can give you more information than kind of what I'm telling you. I'm just informing you of the general nature of things that, at the outset of stuff, if you're going to challenge something, you have to do so quickly and at the beginning. You might also need to file a counter petition. Let's say in a family law case, I've been sued for divorce, and I've got kids, and maybe I want to, sort of challenge things and, put on my own evidence about something. And so a counter petition might be called for in that type of case or in other civil cases. So we have those forms as well. Like I said, I've kind of this sort of slide sort of talks about things a little bit more on this same topic. Like I said, we have answer forms for various types of cases. Some are pre-printed, but we also have forms that you can utilize, special appearance, motion to transfer venue, answers in other types of cases. I always do also mention that, and we also have the petitions, obviously. If you're the petitioner, if you're the plaintiff, we have petitions, pre-printed in certain circumstances, or ones that you would have to edit, say in Word. I always mention this. It's just sort of a little sidebar issue, but sometimes we've had it happen a few times where people come in and say, "Hey, I've been sued in this car wreck case, or I've been sued in, because somebody got injured at my home or at my business, maybe on a small business or something like that." You have most people, at least for vehicles, it's required that you have insurance. It's usually required that you have a certain level of homeowners insurance when your house is subject to a mortgage. Uh, so if you have those types of insurance, very likelihood that there's also a duty to defend. I get in a car wreck case, I get in a car wreck, and then I get sued by somebody saying I caused a car wreck. Make sure you refer that case to your insurance company. Tell them immediately. Forward the suit papers to them immediately. And in general, they have a duty to defend. Same with, say, your homeowner's insurance policy. Say if the UPS guy slips on your sidewalk and breaks his neck, you want to refer that to your insurer under their duty to defend clause to provide an attorney. And if there's an adverse judgment against you, or if they decide to settle the case, they're at least responsible in general for up to the policy limits of a case. So say you get sued, you got $500,000 in liability coverage on your car insurance, and you get sued, and it goes to trial, and the plaintiff wins $150,000. Typically, that then is going to be paid by, unless they contest it in some manner, the insurance company is on the hook for that $150,000 because it is within the policy limits, and hopefully it was covered by what the policy covers. So just always keep that in mind. If you get involved in a civil suit, you get sued, don't forget you might have applicable insurance. Some recent developments, we talk about discovery a little bit more in the companion course to this, Courthouse 102. Written discovery is the means by which parties can obtain information from the other side via various methods. There's written discovery, and you can send things to them, questions to them that they have to answer under oath. Those are interrogatories. Requests for production, that's when you send questions to people requesting the production of documents, relevant documents, to a case. And there's other ones as well. And one of them is disclosures. And disclosures is under Rule 194 of the Texas Rules of Civil Procedure. And there is some basic information about the parties to the case, the nature of the claims, and so forth. And that used to be also optional for the parties. Now it is required that each party in a civil case answer disclosures under a certain time frame early on in the suit. I think for like a defendant in a family law, or a defendant in a civil case, or the respondent in a family law case, they have to do so within 30 days of them filing their answer. So it's just a new development and a requirement now. So I just wanted to apprise you of that. And we discussed discovery a little more in depth in Courthouse 102. So again, just a reminder: be reactive, be proactive. If you're going to handle your own case, you got to do it, and it's pretty daunting. And there's a lot of stuff to know, but that's the reality of it when you're pro se. Being pro se, you want to put your best foot forward. There's a lot of things to know in a case, and like I said, some cases are relatively simple, but some can be very involved. And if you're going up against an attorney on the other side, they know what's they know the law better than you. It doesn't mean you're ignorant or anything. It just means, or it doesn't mean you're unintelligent. It just means you don't know certain things. Why would you know the ins and outs, the details of civil litigation? The devil is in the details, and there can be a lot to know. There's always deadlines happening, and certain, proper ways of doing things under the rules and so forth. And so, we have those materials, and, if you're going to really get involved in a case, it does involve kind of immersing yourself in this stuff and learning it and understanding it as best as possible, making yourself aware of the rules, because the other side is certainly going to use them. So it just, I know it's like I said, daunting, but we have materials here that are helpful, and you're welcome to those materials, and we'll help you with that. So just talking about some other key issues, we talked about kind of the petition and the answer. There's other things you might have heard of. The statute of limitations. That's also contained in that Civil Practice and Remedies Code, Texas statutes. There's certain time limits on which you can sue, or if you're a defendant, under which you can be sued, and it can be a defense if you've been sued outside of the applicable statute of limitations, or it can be something when you're the plaintiff that you have to act within a certain amount of time, or you lose the right to bring your suit. And so there's various time frames for different types of suits. There's certain cases have a 1-year statute of limitations. Certain ones have a 2-year statute of limitations. Certain ones have a 4-year statute of limitations. So it just depends. And so we have that material here, and it can be an important issue, of course. Computation of time. Within the rules of civil procedure, rule number 4 talks about how do you count things. What day do I start? Say if you have 20 days to respond to this. Well, when do I start counting that 20 days? Is that from the day that something is filed? Is it from the day that I get served? Is it start the day after I get served? Do Sundays count when I'm computing a time frame? It's very important. Especially if something's maybe being done towards the end of a time period. You want to react. So there are rules for that. There's rules for a lot of things. And it's just, once again, you got to be aware of these things. What's the minimum amount of time I can have to respond to something? What's the minimum amount of notice am I entitled to for certain types of hearings and such? So again, we have that. It's within the Texas Rules of Civil Procedure. There's that rule and many more. So talking about things in a general sense, there's pleadings and there's discovery. It's kind of what we talk about, the paperwork in a case. Pleadings are things such as the petition that you filed, the answer that was filed, motions within a case, such as a motion to transfer venue if you're going to challenge that. There's really no end to the different types of motions that can be filed. Some are, very well known, and sometimes you can almost make up your own title. It's basically asking the court to do something. It's the way, once you're within the context of a case, someone's filed a petition, the other parties filed an answer, now the parties are in the case is going on, trial is set, a year from now, and we're moving forward, we're conducting discovery, we're taking depositions and gathering evidence and preparing our case and so forth, and an issue comes up that the court needs to resolve. I file a motion with the court, or I want the court to make a decision on a certain issue and the time is right to do that. I file a certain type of motion with the court. That trial date's coming up. Oh, I'm not ready. The trial's in a month, trial's in 2 months. I need a little bit more time for certain reasons. I ask the court to grant a continuance, delay the case for a period of time. Motion for continuance. I'm the defendant, and I claim that the case should be dismissed against me because the other side is not entitled to win under the law or under the facts. So maybe I file what's called a dispositive motion. You're seeking a disposition of the case prior to trial, say a motion for summary judgment or some types of motions to dismiss, depending on what court system you're in and what type of dismissal you're seeking. So there's all kinds, and there's numerous other ones. There's motions related to discovery, sort of another component of a case, and another written component of a case is discovery. In a civil matter, that's the process by which we gather information from the other side via these things such as the request for disclosures, which are now required, or interrogatories, or requests for production, or taking a deposition, an oral deposition, which you may have seen on TV or something like that, where parties sit and ask questions of each other, their lawyer, maybe the car wreck case. I want to take the deposition of the plaintiff, ask them about, what happened in the case and about their claimed damages, their medical damages and so forth, and explore those issues with them. And maybe that might lead me to say, taking that deposition might lead me to say, I'm the defendant in this case. I want to settle because, they've offered a fair settlement and I want to settle instead of risking trial. Or I might say, they don't really have a good case. So I'm going to roll the dice and go forward at trial. And so those are types of discovery and so forth. So those are sort of key components of civil litigation, the pleadings and the discovery. Pleadings, the paperwork is generally filed with the clerks. So you got to file it with the clerk and you got to send a copy to the other side. Discovery is generally between the parties only. The clerks don't want that. It's not required that you file discovery with the clerks anymore in general. So let's look a little bit briefly at sort of the general structure of legal documents. You might see these, when you get a petition served on you, either a civil lawsuit or a family law case, a divorce suit. At the top is called the caption, and that's that sort of the whole block here. It has a cause number, which is just the case's file number. And usually the cause number, has certain numbers in it that will identify what kind of court it's in, what year it was filed. So let's say a criminal case that's filed this year might be 21 dash DCR, so that means District Court Criminal CR, and then 1, 2, 3, 4, 5. That's just a random number. So that was that case, and then the next case that would be filed in a criminal case would be 21 DCR 1, 2, 3, 4, 5, 6. Similar, so there's different deals, but that's basically the case's file number at the top, and then you have the identification of the parties over here on the left hand side. Jane Doe versus John Smith, or the state of Texas versus John Doe, or in the matter of the marriage of Jane Doe and John Doe and minor children, 1, 2, and 3. And then you have over here on the right-hand side just the court identifier. We're here in the District Court, Fort Bend County, 387th Court, or it might be in County Court at Law, Fort Bend County, Court Number 1, or in the Justice Court of Fort Bend County, Precinct 1, Place 1. So then we get down to the title of it, Plaintiff's Original Petition. Usually want to put the party next to it, so Plaintiff's Original Petition, obviously. But let's just say it's Defendant's Motion for Continuance. So you usually want to put at the head, just so they know whose motion it is, Defendant's Motion for Continuance. And then you get down to the body of it, and there's different structures for different types of cases, but basically it's a certain organization of paragraphs, opening paragraph, paragraph describing the situation, a paragraph saying what you want, a paragraph saying why you're entitled to get what you want, either by the rules or by case law that supports you, and so forth. And then there's the conclusion. The court respectfully asks the court grant the motion for continuance, that kind of thing. And then you have the signature block. So when you're signing your documents, whether you're an attorney signing on behalf of the party you represent, or you're pro se, you're signing it yourself. You have your name, you have your signature line, your name. If you're the attorney, you have your law firm, your address, phone number, email, and then who you represent. Pro se respondent. If it's John Q. Public, or if it's, say, John Q. Lawyer, and then you say, attorney for defendant, something like that. Certificate of service, something covered by the Rules of Civil Procedure, of course, Rules 21 and 21A. When I'm sending something, so say, we filed the petition, the case is going on now. When we're sending things to each other, we don't have to have them formally served anymore. In general, there's certain things you do, but in general, if I'm filing, say, a motion for continuance, I send a copy of that motion, and then as part of that motion, there's a certificate of service where you are certifying that you have sent this to the opposing counsel or to the other pro se party, under a proper method of doing so. You faxed it, you sent it via certified mail, even regular mail, attaching it to an email. The e-file system, you can file things and serve them utilizing the e-file system. It's a computerized service. You sign up to do that. Pro se people don't have to. Attorneys do have to e-file now. So that's kind of the structure of the certificate of service. On this day, I served a copy of defendant's motion for continuance on this person by this method, and you sign off on it. So when you're wanting to, ask that court to do something, you have an order. The order will basically be the thing that the court signs if it agrees with you, and it basically tracks the language. On this date, the court considered the motion for continuance of the defendant based on the substance of that motion and the law. I find that the motion should be granted. It is therefore ordered that the case is continued from its current trial date until March 2021. The notice of hearing, same thing. It's a similar structure. If you're going to have a hearing, you have to inform the other side. There's going to be a hearing on the motion for continuance. On March 21st, 2021 at 3 p.m. in this courtroom at this address. You got to give notice to the other side of that, and timely notice. JP courts, they have some rules that are particular to JP courts. In the Texas Rules of Civil Procedure, there's some different time frames for them. Just they have kind of their own little subset of rules within the Rules of Civil Procedure that govern some of the particulars of practice in JP court. One thing that's interesting about just JP court or small claims court is that if you want to appeal from that, you don't go to the Court of Appeals. It's by trial de novo, which means a whole new trial. It's kind of a total do-over. So say you lose that eviction case, there's a way you can get that case then heard again in the county court at law. And then let's say you lose at the county court at law, then you go forward with sort of the traditional appeal process. So like I said, there's different time frames and deadlines and certain requirements in these type of cases. If you're going to appeal, you got to put up a little bond or pay the rent. There's just different rules on things like that. So just want to make you aware of that. Like I said, if you want to appeal something, and we're kind of in the home stretch, so we'll be going a little quicker on these slides. If you do want to appeal, let's say you have a disposition of your case out of the trial court, be it the county court at law or the district court. If you want to appeal, you can do so under certain circumstances to the Court of Appeals. There are 2 Court of Appeals sitting in Houston covering this region. It's a little bit of an anomaly, but just know that. And so generally you file a notice of appeal. Again, there's always deadlines running. Always know that if there's a final order issued, you got the time is running, the clock is running for you to react to that. Are you going to file a notice of appeal? You can also then go forward. There's the ability to get to the Supreme Court of Texas or the Court of Criminal Appeals. Those are the 2 highest courts in Texas, one handling civil matters, the other handling criminal matters. There's Supreme Court. Cases can be appealed out of the states to the U.S. Supreme Court, though their jurisdiction, their docket is discretionary in general. They choose the cases they want to hear. So the Supreme Court, aside from weighing in on, like, say if somebody's going to be put to death by the state in a criminal case, they do handle those cases and so forth. But, the cases they actually fully issue opinions on, it's less than 100 a year, and they're usually, matters of import to the whole nation or on issues that are dispute, say, between the federal circuit courts. But there's also other things besides after your trial is over or you have a final judgment in your case, at the trial court level. In addition to filing an appeal, you have some other options: a motion for new trial, a motion to modify, things of that nature. There's other types of appeals: mandamus, bill of review. Not really appeals, but there's other things that can happen once there's been a disposition in a case or an order issued. So just to kind of apprise you of that. But like I said, say if you lose at the trial court, you have some options. The clock is running always, of course, and it's a relatively short amount of time to choose which route you want to go. Do I want to file a motion for new trial, basically ask the court to do the trial over again for some reason, or do I want to go straight to the appeal process? And again, we have materials on that, both at the state and federal level. So just like I said, when your case gets over, the clock is running, to decide what to do, if anything. You might just say, I lost. Okay, that's the way it goes, and I'm not going to pursue it any further. But just as in another reminder, in litigation, generally the clock is always running in some way, shape, or form as to some issue. So just always be aware of that fact. As I said, the Fort Bend County website, I mentioned that earlier, as a way of getting to information about various departments within Fort Bend County, such as the district clerks or the county clerks or the courts. You go to fortbendcountytext.gov, and then you go to the government tab, and then that allows you to access each department's sub-web page. Finding an attorney, like I said, on the criminal side of things, if you can't afford an attorney for you, just like you always hear in the TV shows and the Miranda warnings, one will be appointed for you. That's where the Indigent Defense Department of Fort Bend County comes in. Attorneys can be appointed for you. Those attorneys are, there are some attorneys in the Fort Bend County Public Defender's Office, but a lot of it's done by private attorneys. Take cases on appointment from the courts, the criminal courts here. That's a very common thing. Legal aid organizations, if you're in a civil case and you are indigent, you don't have the money to afford a lawyer, there are some organizations that do their best to try and help. I'm not going to say don't rely on them, but they're resources are limited, the amount of people they can help are limited, the type of people they can help are limited to folks who are at the lower end of the economic spectrum. So, for a lot of people, they're not poor enough to basically get legal aid, but, it's not cheap oftentimes, even for, to hire an attorney, or people just can't, handle that expense. I'm not going to say it's overly expensive, but let's just say attorney wants a $2,500 retainer or something like that, which is not atypical. A lot of people just simply can't afford that, so they're going to try and go forward themselves, and that's what we're here to help people who are representing themselves by choice or necessity. That's what we're here for. So anyway, there's some various organizations. Lone Star Legal Aid is one of them. There's other ways you can find an attorney. The Fort Bend Bar Association, the local professional association, they have an attorney search function on their page via category. So, I want to find a family law attorney. I can search on their webpage for attorneys identified as practicing in that area. It's not a recommendation of those attorneys. It's simply a listing of folks by practice area. There's other ways you can, be referred to attorneys in certain practice areas by the Houston Law Referral Service or the State Bar. Just some other helpful resources, just some different websites. Our library website, the Fort Bend County Appraisal District, that's a listing of property in the county, who owns it, and so forth. In addition to also, you can find that information through the clerk's office. Texas Law Help, it's a website that we use a lot. It's really indispensable to what we do, especially on the family law side of things. A lot of the standard forms, not everything, but a lot of what we utilize in helping people print up for them, fill in the blank forms to try and help people with basic forms, that are pretty complete as well. It's an excellent website, and we use it a lot, and we're lucky to have that one. That's that last one listed there. So when somebody comes in and says, hey, I want to get a divorce, I don't have any kids, and my spouse has agreed, we hand them a certain packet of documents from that website. Very helpful. Like I said, here's our contact info, my email, my boss's email, our information, where we are here in the County Justice Center. We have, I know things right now we can't let anybody in, and I can't wait to the time, I'm sure we all can't, when things get more back to normal. I've said that a billion times, and as we all have. When this gets back to normal, we're making do as best we can, and I think we're doing a good job of still helping people. I know it's not ideal, and it's not as good as it was, but eventually people will be able to come back inside, use themselves, our excellent resources, on our computers, our legal databases. We've got printers and copiers and books and scanners and conference rooms, meeting rooms. We got Wi-Fi for free. Just all those things. And we're still able to use those, but we're sort of the middleman on that for you. So, like I said, just because we're under the certain protocols right now, don't let that dissuade you from seeking our assistance. We'll do our best to provide the same level of service as if you were able to come inside. Like I said, we've got these excellent databases that we utilize, that we subscribe to using our budget, the money that is allotted to us. We'll use it well. And getting a very in-depth materials, both in print and online. And then that allows us to deliver those documents to people in many modes. If we can print things out for people at minimal cost, we can email things to folks, and say in Word so that they can be used by them, say forms or something like that. Just, a lot of our resources, and we're able to provide them in different ways, for the convenience of people. It's very user-friendly. Like I said, most of our stuff that we have books and online stuff, and most of our stuff is has anything we have in the books we generally have online as well, and vice versa. There are some things we have only in print. There are some things we have only online, but for the most part, we have it in both modes, and whatever kind of way people are most comfortable accessing those. Just a little picture. That's our door. We're on the second floor of the Justice Center. Parking's free here. Parking garage. So that's really good. We're pretty user friendly here all around here in Fort Bend County. So like I said, you don't have to pay to park. There's a garage. It's 100 yards from the front entrance of the building. So you do not have to walk 5 blocks downtown and pay $20 to park. Nothing against other law libraries. It is we're lucky in that we're a little more user friendly, I think. We've got this is kind of a view of our law library under during happier times, of course. So you can see people there working at the computers. This is one of our assistants. These are our meeting rooms. I'm sitting in this room right here. Right now, this is our main conference room. These are our smaller meeting rooms. Our books you can see over here on the other side. So it's a nice setup. We've got windows. A few years ago, we moved into this new location a couple of years ago, 2.5 years ago now. We used to be on the third floor and we didn't have any windows. Now we're on the second floor. We've got windows. We're a little bit bigger. Just a little more to offer our patrons. So it's definitely improved and grown over the years. This is another view of our place, our printers, and some of our small meeting rooms and our computers. Some of our work tables where you can sit. Our copiers over here. These are general computers right here. Some of our book collection, our printing collection, work tables there as well. So, like I said, I think this is a really good law library. I'm partial to it, but I think objectively it's a good law library, and we're privileged to help you. Like I said, upcoming course, I can't remember when exactly, the next Courthouse 102, sometime the next few weeks. And we just get into a little more detailed information about, the structure of a lawsuit and what we have to assist people in doing that. Any questions by anybody? I know I've talked a lot. Does anybody have any questions?
No, sir, I'm okay. Thank you.
I'm sorry? I couldn't hear Ms. Mafood.
No, I said I'm okay. Thank you so much. Thank you.
Thank you, Mr. Perkins and Ms. Mafood. I'll send you a copy. I'll send both of y'all a current copy of the PowerPoint, and it has my contact info. You'll have my contact info, and if you need anything, please ask. I really appreciate y'all attending the course. Thank you.
Thank you.
All right. Bye-bye, y'all. Bye, Ms. Mafood. Thank you.